Welcome to another edition of our professional webinar series. Today, we are focused on the topic of human rights, a subject that is especially important to all of us at Epilepsy South Central Ontario, as well as we guide people with epilepsy, our clients, through some tough situations sometimes. We have two guests today, both lawyers who care about our community and who are giving of their time to provide us with some very important information. Michael McHugh is a partner at the law firm McHUGH WHITMORE, located in Stony Creek. Mike's practice area includes corporate commercial real estate, estate planning, and estate administration. Within his estate practice, Michael tailors wills, powers of attorney, and trusts that best suit his clients. Michael currently sits on the board of Epilepsy South Central Ontario as secretary and as a member of the Hamilton Law Association and East Hamilton Business Network. Mike will be leading the discussion today with our special guest, Wade Poziomka. Wade is a partner at the law firm Ross McBride located in Hamilton. He has dedicated his legal career to ensuring that the voices of marginalized members of our community are heard. Wade passionately advocates for his clients, and his practice is dedicated to human rights, union-side labor law, and employment law. Wade currently serves as chair at the Ontario Board Association's Constitutional, Civil Liberties, and Human Rights section, and sits on the executive of the Canadian Bar Association's Constitutional and Human Rights section. Wade was appointed to and currently sits on the Human Rights Tribunal of Ontario's Practice Advisory Committee. I welcome you both, and I now pass the podium over to you, Mike.
Thanks, Cynthia. So today, as Cynthia suggested, we are going to be having a conversation with Wade. Wade is a lawyer that specifically practices in the area that I think many of you may find quite interesting, and you might have some questions along the way. He's going to present a PowerPoint slide, and he's going to present specifically on human rights as it relates to epilepsy. So I think it'll be quite interesting, and I might as well just bring Wade into the conversation right now.
Thanks, Mike. Yeah, before we start, I just want to say what a great program this is that Epilepsy South Central runs. I've had an opportunity to look at a couple of the conversation pieces, some of the videos, and this is great. It's really fabulous. I think more organizations should be doing this kind of work and outreach.
Great. So I guess I imagine you, as everyone else, you're working from home these days.
So I've been working from home since early March. I went away over the March break and never came back. So that has its challenges. My practice is in human rights, so a lot of the work that I can do is by teleconference or video conference or email. So I've been doing that kind of work. The only struggle is I have 4 children aged 7 and under. So the odd time there's a scream through the office wall. So that's the struggles I'm dealing with these days.
Yeah, I think that's the commonplace these days. So, I mean, I think the way we might structure this is just, I know you've prepared this PowerPoint, so I think it might just be best if we get right into it, and then as you address certain issues, maybe I'll just chime in to ask a question or two, or if we do have any questions from those watching, feel free to put those to us, and I'll raise them with Wade as we go along. So yeah, why don't you get started, Wade?
Great, thanks, Mike. So I put together a PowerPoint that I'm going to start in a moment, and what I really want to do is just give you an overview of the Human Rights Code, what human rights are, some things that you should be aware of in case you ever deal with a human rights issue. And a lot of it's legal. I'm going to try to not make it so legal, but if you have questions, like Mike said, please jump in and ask me. It'll make it more interactive, and I can take a break from my slides for a moment if you do. So we'll get started here. Okay, so Mike, can you see my slide there?
I can, yep.
Great, so it's working. Okay, so the first thing I wanted to talk about is what are human rights? So a lot of times people will call me or even file an application with the Human Rights Tribunal, and they'll say my human rights have been violated, and it's not always the case. So general unfairness from an employer is not necessarily a human rights issue. To be a human rights issue, it has to touch on one of the grounds that are up here on the slide. So age, and what I've done is I've bolded the most common grounds that we see in the human rights world. So age, disability, family status, and sex, which is gender. And that includes pregnancy as well. The most common ground that the Human Rights Tribunal will see is disability. And that's what we're going to focus on for the most part today. So again, in order to be a human rights, it has to be under one of these grounds which are set out in the Human Rights Code. Disability is actually defined within the Human Rights Code itself. And there's a big long definition, but I've taken a piece of it out for you here and put it in just to show you that it specifically says that epilepsy is a disability recognized by the Human Rights Code. So often in litigation, you have to go through, establishing that it is a disability. If you're bringing your application as a result of epilepsy, you can skip that part of the test because it already is a recognized disability in case law and as it's set out in the code. Now, human rights also has to be in a social area that's protected. So for example, if your friend calls you on the telephone and says something discriminatory to you, that's not a human rights issue that the Human Rights Tribunal of Ontario would deal with because it's not within one of these social areas that you see here. The most common social area that's protected is in employment. So that could be harassment based on a code protected ground or inappropriate comments that are made or not getting a promotion or another opportunity in the workplace because of a disability, for example. Those would all be examples of discrimination in employment. Another social area, and the second most common, would be goods, services, and facilities. So this could include treatment from police, being in the education sector, not being accommodated properly if you need accommodation, things of that nature. And then the third, and the other most common, is housing. Contracts and membership are kind of grounds that aren't touched upon. So really it's employment, housing, or services where the code protects individuals on the basis of disability. Now there's different forms of discrimination. So direct discrimination can be something very obvious. Mike, I'm not going to hire you as my employee because you're male. I only hire females. That would be discrimination against Mike on the basis of his gender. The more difficult type of discrimination to recognize is the second one, and that's constructive discrimination. So that happens when there's a neutral policy that an employer has that applies across the board. It applies equally to everybody, but it impacts somebody differently because of a code protected ground. So let me give you an example of what that might be. I had a case, years ago now, where my client worked in an organization where he was doing phone calls. And the employer had a policy that said, everybody in the call center has to do 800 minutes of phone calls per month. And if they don't, they're disciplined, they could be fired. And we don't care what the reason is, this applies equally to everybody. Now, my client had cancer, and so he missed a few days that month for treatment. And so his minutes came under the 800-minute threshold, and he fell short and he was terminated. And the defense that the employer raised is, well, look, we have this policy that applies equally to everyone. We didn't know he had cancer. It's everybody no matter what. And the tribunal said, well, no, you might have a policy that applies to everybody, but you have to make exceptions and accommodate people, right? So if they're there for a code protected ground, cancer obviously is a disability and is a code protected ground, you have to accommodate somebody. You can't apply the policy that applies to everybody to that person. And if you do, it's constructive discrimination. So that's another way to get at discrimination. And in my practice, I typically see constructive discrimination a lot more than direct discrimination. It's very rare that someone says, I'm going to do this because of this. It's more that we have these policies, they apply to everyone, and you're caught up in them kind of. And that's the element that I typically see. Systemic discrimination is something that's not limited to individual behavior, but it's systemic through the organization. So, that could be something that a number of people perpetuate, and it's something that's part of the culture of an organization. And those are really serious types of discrimination that you want to allege systemic when you bring your individual application, because you want to get at the root of the problem in your workplace. And so if it's something systemic, you're really going to be focused on public interest remedies, and that could be training. It could be posting the human rights code in the workplace, creating and developing policies which the employer is required to follow. And so that's the third type of discrimination. The next slide is if you're experiencing harassment in the workplace, or if you feel you're being targeted because of a disability, it can be a human rights issue, and it is, because disability is a ground protected by the code, but it can also be a separate harassment issue under the Occupational Health and Safety Act. And I say this because it's important to understand that you have two possible routes that you can go if you're experiencing this type of behavior in your workplace. And employers have an obligation to investigate. In the old days, somebody would come forward with a complaint. I think my boss did this to me, for example, or I don't think I got this promotion because I have a disability or because of the color of my skin. And the employer could say, well, are you making a formal complaint? And a lot of times people would say, well, I guess not, because that probably means something bad for me. I'll be a whistleblower, maybe I'll be reprised against or retaliated against. And so they wouldn't make that formal complaint. Now, with the changes to the Occupational Health and Safety Act, employers have to investigate complaints and incidents. And what that means is that they don't have the opportunity anymore to say, are you making a formal complaint? Once they become aware of something, whether there's a complaint or not, they must investigate. And if they don't, they're breaching the Occupational Health and Safety Act. So that's something to keep in mind too, if you raise a concern with your employer and no steps have been taken. The biggest part of human rights, where most of the work is spent, is around the duty to accommodate. The duty to accommodate, I'll just kind of give you a bit of an overview of what that means. There's two parts to it. There's a procedural obligation or component, and there's a substantive obligation or component. The first, the procedural, means that the employer has to look at the individual needs of the employee, and then they have to assess their workforce. And basically, it's a brainstorming exercise that should involve the employee. And you want to come up with every possible scenario of how accommodation could be implemented. Then after you've done that, you get to the next part, which is the substantive. And the employer's obligation is to accommodate to the point of undue hardship. And so it's really important, because in the past, the employers would skip this. They would just say, oh no, we can't accommodate that, without a second thought. And the answer would be no if something was asked for. If that happens, and it's kind of a knee-jerk reaction, and there's not that engagement with the employee where there's that brainstorming and looking at options, that alone is a breach of the Human Rights Code, even if at the end of the day they couldn't accommodate the employee. So it's important for you to understand that a breach of the procedural component is enough to be discrimination. And that's why it's so important that when you flag an accommodation need with an employer, that they sit and they take those steps. The other things involved in the duty to accommodate are respect for dignity, individualization. So one person's need, even if they have the same disability, could be very different from another person's need. And so you don't have kind of this blanket approach you take. You ask questions, you gather information, and you individually look at assessing that employee. And integration and full participation means that you try to modify the workplace as an employer to make the employee be able to participate fully or as to the fullest extent possible in the work that they're doing. And the best thing that employers can do is think about this in advance. So think about inclusive design. So when you're creating policies and you're looking at setting your workplace up, think about, we are going to have employees who have disabilities, and we are going to have employees who will have accommodation needs. So how can we address that in advance? And how can we make our workplace accessible? How can we have policies so people can come forward and make these accommodation requests? How can we make employees feel protected if they're experiencing discrimination and they want to raise that with their manager without any retaliation or repercussion? So all of these things could be at the front and center when you're developing your policies.
So specifically speaking, sorry to interrupt, but specifically speaking for individuals with epilepsy, what would you be able to provide some examples of what an employer's obligation might be to accommodate someone who does have epilepsy in the workplace?
Yeah, so, and I'll invite Cynthia to jump in here with me as well. We've worked together in the past on human rights cases, and so I know she's very aware of different types of accommodation. But one type of accommodation that I've come across in my practice that individuals with epilepsy may require is a set shift time. So not having rotating shifts in case they're taking medication for epilepsy and it's impacting them. So that would be a common accommodation that would be asked for from my perspective. They would approach their employer and say, you know, I have a disability, I'm taking medication, and I need to have a set shift. Can that be done? And it's important here to understand that the employee doesn't necessarily have to say, I have epilepsy. They don't have to disclose their diagnosis when they're making the accommodation request. They can, and my preference is that they do, because it just takes away some of the ambiguity down the road when you get into litigation, if you ever get there. So from a lawyer's perspective, I like it, but they don't have to. They just have to trigger that there's an accommodation need and that it's connected to a disability. So Cynthia, maybe you have some other examples of accommodations you've seen.
Well, yes, and it's easier in a smaller organization than a larger organization. I think we've found accommodating someone, it is very important that they regulate their sleep and their medications. And so in your earlier explanation about, you know, the employer put together a policy that applies to everyone. Well, this does happen in factories with shifts, and people are supposed to rotate those shifts. So it's an extra special accommodation to allow that person to just do days or evenings, whichever works best for their condition. Yeah.
So, and then Wade, you kind of alluded to the fact that there's no, I guess, positive obligation for the employee to necessarily disclose that they have epilepsy. And I think this is, you know, one of those disabilities where it's, you know, people don't always necessarily wear it on their sleeves. And I'm just interested to know, though, when you get into that accommodation process, what's the employee, or how is the employee expected to participate in that process?
Typically in most cases, I would think that an employee, at least with upper management or with human resources, would disclose that they have epilepsy. And at that point, then there'd be a discussion around, well, how does it impact you? What type of epilepsy is it? What do you experience seizures? And so there'd be that discussion. And then there would probably be a discussion about, well, what can we do? What should we do if a seizure happens, for example? And just listening to the employee, right? Because everybody's different. You can't go on Google and type epilepsy and assume that applies, or what you find applies to every single person. Everybody is different in terms of what they experience. And so I think rather than just the employer assuming they have the answers and they know how to accommodate, listen to the employee, right? They know their condition better than anybody. Mm-hmm. And that's a really important step that I think is often forgotten. I think somebody says, I have epilepsy, or they experience a seizure, and the employer really steps back. And it's not that they're a bad employer, but they're an ignorant employer. They don't understand what they should be doing. So they step back and they put their hands up and they say, go get all this medical evidence. We need to make sure you could never have a seizure in the workplace. This is so serious. Our customers could see. And they kind of take that approach. And that's the wrong approach from my perspective. And I think that's what we see too often, because I think epilepsy isn't really as understood as it could be, as it should be by employers. And that knee-jerk reaction is to say, go get us this swath of information, medical information.
Yeah, we do some training in a workplace. If someone has disclosed and then their employer would like more information, our agency will go in and will train those employers or the colleagues closely working with the individual. And that usually helps with the duty to accommodate. The employers can be quite understanding in that way. It is often just fear that they have, and of the unknown.
And that's actually how I met Cynthia. I can't talk about the specific case, but Cynthia was involved in a case I had done in the past where she was helping to educate an employer around epilepsy and accommodation needs, and it was great. What I've often seen is that when somebody says, I need this accommodation, especially if it's a shift, if it's, I can't work night shifts, for example, they're going to automatically think this employee's using that accommodation request to get preferred treatment. their coworkers are going to be upset. How's this going to impact our workplace? And so it's really important to have somebody, whether that be a lawyer, but preferably Epilepsy South Central, to step in and talk to the employer and say, no, this is why this is necessary. This is why we should be going this route. Here's what happens. And explain it from kind of that neutral third-party perspective, so the employer starts to understand and they don't think it's an employee trying to use a disability to gain an advantage. Because that really is something I see too often. They're worried about employee morale from other people. Everybody will ask to work day shifts, for example, and they kind of go down that path of thinking. And so I think somebody like Cynthia and Epilepsy South Central can really pull that back and help.
Great.
Yeah, we do try. We do.
Yeah. Okay. So the duty to accommodate requires that the employer accommodate the employee to the point of undue hardship. And undue hardship, it's really important to understand this because it's not clear in terms of what does that mean. From my perspective, in the way I read undue hardship, it only has 3 factors. So cost, outside sources of funding, and health and safety. Now, if there's an accommodation needed, the employer could argue cost. In most cases for persons or individuals with epilepsy, they're going to be hanging their hat on health and safety. And from my perspective, again, the standard that they set is one of perfection, right? Some employers will say, go get a medical note that says you can't have a seizure in the workplace. Well, no doctor is going to write that. So nobody's going to get that note. So if that happens, you're basically saying because an individual has epilepsy, they can't work. And, or they say, you're in a manufacturing setting and you could fall and hit your head on the floor, or they come up with these very kind of, gruesome examples of what could happen. And they say, it's just, we're not going to let you come back until we have assurances it's not going to happen. When really what they should be doing is looking at how often do seizures occur? What happens when they occur? What's the likelihood of injury? Have you been injured in the past, for example? What can we do to lessen the injury and let you do your job? And if there's some risk, and there's probably always going to be some element of risk, do you want to assume it? So if you say, look, I know that something could happen and I could become injured, but I'm prepared to take that risk and it's not going to be a serious injury, it's going to be something mild, then employers should just accept that. Maybe ask for some medical evidence, but don't ask for a perfect standard and keep the employee off work for 1, 2, 3, 4 or more weeks so they can't earn an income while you're seeking this information. If they've been there working, ask for the information that's relevant and that's necessary in a very reasonable way, but let the employee keep working while you're doing that, especially if there's no significant safety factor at play. So again, when I say that the factors are limited in the undue hardship analysis, what it means is that other employees getting upset, for example, doesn't matter. So somebody thinking, oh, John's getting preferential treatment because he only has to work day shifts, too bad. That's not a factor that employees can or should consider when it comes to human rights. And if they do, and they advance it, the tribunal is going to tell them it's not a factor and they're going to find discrimination. It's not a defense. What you can do as an employer to kind of lessen that impact is make your workforce aware that sometimes there's reasons for accommodations. We're not going to tell you what they are because you don't have a right to know. It's private. But sometimes there's reasons. So if we're doing these things, don't just assume we're giving preferential treatment to somebody. We're probably accommodating them. And let them know that any kind of gossip or retaliation or ill treatment towards that individual will result in discipline, including and up to termination, because it's not acceptable. It creates a poisoned work environment.
Okay. Yes, and epilepsy is combined with stress. Stress will trigger and this, if there's undue hardship in the workplace, it's only going to escalate the incident of a seizure, perhaps, because if you just work it out with your employer and the employer is reasonable, then you're going to have the most productive employee. For one thing, they're going to like their job. They're going to feel comfortable in their job. You're going to get the most out of them. It's a win-win once everyone understands each other.
Yeah. So we've been kind of generally just speaking about human rights in the workplace. Now, as it relates to epilepsy, in your experience, you practice exclusively in human rights and employment law. So, I'm sure you've seen it all. But specifically as it relates to individuals with epilepsy, are there often human rights issues arising in the workplace for these individuals?
Yeah, and I think as it relates to epilepsy, it's a little bit more difficult because, you know, the most common disabilities that I come across are generalized anxiety disorder, depression, or PTSD. And from my experience, employers typically understand depression and anxiety more than epilepsy. And so when it comes to epilepsy, they don't fully understand what that means. And so there's that assumption that it's something that's serious, and that there's a need for all of this information, and there's a significant health and safety risk. So I think epilepsy more so than other disabilities, some of the disabilities that I see more common, the reaction is more kind of extreme, uneducated, and typically what you see is the employer saying, go off work right away. So somebody has a seizure in the workplace, for example, and the employer says, go home until we can have medical information. They start asking all sorts of questions. So I think just because it's not as understood, or it's more often misunderstood, it's more difficult to deal with because there's more need for the education component. But really, I mean, when you think of it at the end of the day, it's not the employee's obligation to educate the employer. Maybe to the extent that, you know, the duty to accommodate requires that employee to talk about their specific needs, but employers should go out and educate themselves or ask questions of medical professionals rather than put that onus on the individual employee. So I do come across cases involving epilepsy a fair bit, and they are a little bit more challenging than the typical human rights cases from my perspective.
Good. So, and I mean, maybe I'll just let you continue with your presentation, but I am interested to know if there is any case law and as it relates to epilepsy.
Yeah, so there's a couple cases that are kind of key cases or bigger cases. So I put the citation up here. Anybody who, I mean, legal writing and decisions are typically boring, so I'm not going to mislead you, but if anybody has an interest of taking a look at these cases, you can go on Canly, which is a free site, and you can type the citation at the end, so 2008 HRTO 23 into Canly, and it will pull up the decision, and you'll have a chance to read it if you're interested in that. I'm going to take an opportunity just to summarize these two cases because in terms of the Human Rights Tribunal of Ontario, these are kind of the bigger cases that have happened in the last decade or so. So the first is Ravi D'Souza versus 1469328. So this is a case where Ravi worked as a tennis coach at the Joshua Creek Golf and Tennis Club. And Ravi was diagnosed with epilepsy, and his initial diagnosis was petit mal, and then it was changed to complex partial epilepsy. And the way he described the seizures that happened to him were they were absences or blackouts. So he had some awareness of his surroundings, but he was unable to fully comprehend or respond. And when he was in the workplace, he was playing a tennis match in November, and he experienced a seizure. And what that looked like to the person he was playing with was that he was talking in a strange voice that wasn't his normal voice. He was pacing around the tennis court, and he was swinging his racket in an unresponsive way. And so that happened twice actually in November. And the general manager then questioned Ravi and said, you know, what happened? And Ravi said, you know, sometimes I have absences or blackouts. And he also informed the general manager that he was taking medication for that. And that seemed to satisfy the general manager at that time. But a month later in December, Ravi was having lunch with the general manager, and he experienced a third seizure that resulted in him sliding to the floor. And as a result of that third incident, the general manager sent Ravi a letter. And I'm just going to read some parts of it because it's interesting. So the general manager says, "Your neglect to let me know about your condition from the outset of your employment and even after having seizures is an issue." So one, they're putting a burden on Ravi saying, you should have told us right from the start of your employment. The next thing they say is your situation has been discussed with the board of directors, and we ask that you provide us with more detailed information on your condition for our assessment of how it relates to your safety at the club and liability for us as employers. Until such time, we must suspend your court responsibilities. So go get us this information. We're worried about safety, but we're also worried about our liability. And until you do that, you're not going to be coaching anymore. And then there's 4 asks. It asks for a letter from a doctor or a neurologist. It asks for written information on how staff members are to handle the situation should a seizure occur. It requires Ravi to inform staff members and tennis students about his condition. So they're saying, go tell everybody who you could possibly come into contact that you have epilepsy and what could happen. And then the fourth is they wanted assurance that he was regularly taking his medication. And Ravi said in the Human Rights Tribunal hearing, because this did go to a hearing before the tribunal, he said, you know, the reason I didn't disclose it is because employers tend to overreact about epilepsy, and he feared that overreaction. And from my perspective, that's quite legitimate because that's what I see as well. And that's why I counsel anyone not to disclose epilepsy in the hiring process. Employers don't have a right to know that. They have a duty to accommodate. And because there is a lot of fear and overreaction to epilepsy, it might prevent you from getting a job. And so my advice to someone who were to ask me that is, do not disclose it in the interview process. The other thing Ravi said in the human rights hearing is, I've been playing tennis safely for years and nothing's happened. I have seizures and there's been no injury. And so the tribunal said, okay, well, listen, the employer is entitled to make reasonable inquiries about an employee's health status in order to ensure the safety of its employees and clients. So it was fine with 1, 2, and 4, but it said number 3, the requirement that Ravi have to go tell everybody, that's problematic, and that violates the Human Rights Code and amounts to discrimination. The tribunal also discussed the danger risk here. And because what the employer said is, well, Ravi would swing his racket and he was unresponsive. So what if he was coaching children, for example, and he struck them with the racket? And the tribunal dismissed that fear as a minimal risk. And it said that while swinging the racket could potentially injure a player, this potential is both remote and the level of injury it could potentially cause is mild. So yeah, there's some risk, but in the grand scheme of things, it's mild, it should be accepted. It's not something that should prevent Ravi from working. And the tribunal also said that the law is clear that a person with epilepsy does not have to disclose that information at the hiring stage when it doesn't impact their ability to do their job. So what happened in this case is the next summer, there were 3 coaches and the employer said, we're gonna hire 2 back, but they didn't hire Ravi. And they had a lot of evidence around performance issues and the needs for the club at that point. And they presented that. But in the termination letter where they weren't bringing Ravi back, they laid it all out. They said, we have these performance concerns, but they also said, you could have handled your situation better, basically, by telling us about the fact that you had epilepsy up front. And so the tribunal said they accepted the performance issues, and they even found that Ravi wouldn't have been hired back even if he had not had epilepsy. But they said the fact that the epilepsy was one factor in the decision not to terminate or to terminate is discrimination. And so they ordered $15,000 in general damages and issued that decision. Damages are too low. I say that about every human rights case. They need to go up so they're not a license fee to discriminate against people. Employers need to feel it. But I think it's an important decision because it sets out the general principle that you're not required to tell your employer in the hiring process. And it also highlights for employers the fact that if any part of the decision, even if there's other reasons, has to do with a disability, that's enough, even if it's 1%.
I find it interesting that you're, raising the points that you are in this case because, and I didn't mention this earlier, but I'm just monitoring some questions coming in, and that's a very prevalent theme. Is even before you kind of started discussing this case, is individuals asking, what is my first off, duty to disclose, and when should I disclose this to a potential employer or an employer? So that, providing that insight on that case where you actually have case law that speaks specifically to it is, I'm sure, very valuable to the individuals listening right now. Now, I guess what I might ask you, and this might just be more anecdotal, is what's your view? Because the people are asking, they want to know what your 2 cents are in terms of when do you disclose this? Do you disclose this in the interview process? The fact that you have epilepsy and it may, become an issue while at the workplace? Or do you think that, as is the case here, there is no real requirement to disclose, but I don't know, maybe I'll just leave it there.
Yeah, so I'll respond to that. And Cynthia, I would invite your response on that as well to see kind of what your thoughts are. But from my perspective, I think what I would say is don't disclose it in the interview process. A lot of employers discriminate, and I see it. I see it kind of in the last 10 years of practice in terms of what I'm doing. And they never say, we're going to discriminate, or we're not hiring you because you have epilepsy. If you disclose it, some, not all, there's lots of good employers as well, but some employers will not hire you. And they're never going to say it. And it's going to be a circumstantial evidence case where we're going to have to try to dig evidence out to try to connect it to the fact that you disclosed. And so my advice is don't disclose it there. If after you get the job offer and you're hired, if you need accommodation to do the essential elements of your job, you can disclose it at that point and request accommodation because you're an employee. Or if there's a significant health and safety risk, I think that the employer, not everybody in the workplace, but a few key people should know about that so there can be a plan in place to make sure that you can do your job safely. So it's after the hiring that I would disclose it if there's a reason. If there's no health and safety risk and no need for accommodation, don't disclose it. Cynthia, what do you think about?
Yes, it's in their best interest to put their best face forward, their resumes there. They're trying to sell themselves as themselves and what their abilities are. And then after they've, they're comfortable in the workplace and established, if it's necessary, if the episodes could happen during work, then it would be, that's what I feel would be appropriate. I think there's a lot of interest both ways, because if the employer does know when they are trained, then if a seizure does happen, then everybody knows the protocol and it's not going to be as much of a shock.
Okay. So I noticed that there's about 20 minutes left in our session. So we are, and we do have other questions coming in. So I'm thinking maybe we'll just try and get through the slides quickly, and then we can get into a bit of a question answer period, if that works for you.
Yeah, that sounds good.
Not to rush you along.
No, rush me. Okay, so I'll just talk a little bit about the second case, and I'll just go to one more slide that I think is important in terms of what medical information can an employer ask me to get from my doctor. So the second case here is Thompson versus 1552754. And in this case, Joan Thompson was an employee who worked as a counter person in a coffee and donut shop. And in 2009, Joan missed 3 days of work. And it wasn't related to epilepsy, but her employer thought it was. And they said, you can't come back to work until we have a letter from your physician saying that epilepsy doesn't prevent you from doing that. There was an issue with assigning Joan regular shifts before for medication, something we've talked about that's kind of common in these types of cases, but that was worked out and there was no need for any other accommodation in this workplace. And so she provided a note from her doctor where they said Joan was off for these 3 days for medical reasons and that's it. So she justified the 3-day absence, but her doctor wouldn't give her a note guaranteeing that she wouldn't have a seizure at work, of course. And the tribunal recognized that there's some risk in having a seizure, but this isn't a coffee and donut shop at a counter. And the tribunal seems to accept the argument that the applicant, Joan Thompson's lawyer, made, where he said a person with a disability may wish to assume some risk. He submits that there was no real evidence here to suggest that there was a serious risk. And if there was, she was entitled to take it, providing that there is no serious impact on health and safety. The factors for determining the seriousness of risk are the nature of the injury, the severity, the probability of it happening, the real or speculative nature, and the scope of the risk. And so it's saying don't jump to conclusions. The tribunal saying take those factors and assess what is the real risk, how likely is it to happen, and what can we do to lessen it. And at that point, let the employee continue to work. The tribunal said it was okay to ask for information, but it shouldn't have set that impossible standard by asking for the medical information that it did. It basically required that Joan return to her prior state, or they called it normal health, which is completely inappropriate. And so the tribunal found discrimination, and in this case ordered $12,500 in general damages and lost wages, which I think amounted to $4,000 and change. So that's the second case. And that's important too, because it gets into the risk factor and where employers may go with that. So the last slide I'm going to talk about here before I take my PowerPoint down is what medical information can an employer ask for? So they're not allowed to ask for a diagnosis in most cases. They can ask for functional limitations. So what can the employee do? What can't the employee do? Those types of things. Rather, they can say, is there a disability, for example, but not what is it? They can confirm that the employee is following their doctor's advice. They can ask how long the accommodations might last for. And they can also provide a job description or a PDA, which is a physical demands analysis, to a doctor to say, is this within the employee's functional limitations? So really it's about functioning. It's not about the disability and labeling. And if they ask those questions, those are appropriate questions. If you get a note from a doctor, and this happens often, or from an employer to bring to your doctor, and again, it happens often, and it says, what is the employee's disability? Call a human rights lawyer, because that question on its own is probably discriminatory and enough to bring a human rights application, and you don't have an obligation to answer it. So just keep that in mind when there are these requests made of you in terms of what your obligations are to respond to that. So I'm going to discontinue. Okay.
All right. So I see as we're going through this, I kind of want to place myself in the shoes of an employee who has epilepsy. What should any of our viewers who are watching, what should they do if they believe that they are facing discrimination on the basis of them having epilepsy?
So I would say as a first step, talk to your employer. So explain why you think whatever's happening is improper, and see if they take kind of a corrective approach rather than a we've done nothing wrong, this is how we do it approach. Mm-hmm. Sometimes you'll fix the problem right there, and it's an easy, simple fix, and you can move on. If things don't get better, or if you feel that they're not listening to you, the next thing I would say is reach out to a lawyer who has some specialty in employment and human rights and have a discussion about what the employer's obligations are, what have they done, does it breach the human rights code? And when you're doing this, what's really important in terms of human rights, different from other areas of law, is that it has a very short limitation period. So if an event happened in the workplace that you think is discrimination, you have to file your human rights application within 1 year. And the tribunal is very strict on that. I've had cases tossed out when it's been 2 months beyond that 1 year. If you miss that limitation period, short of a disability reason preventing you from being able to advance your case, you're going to be out of luck. So I would say, try to talk to the employer first, but then as quickly as possible, if things go south, reach out to somebody and have that discussion so they can advise you what your limitation period is and what your rights are.
Mm-hmm. Okay, so let's say someone does make a claim at the tribunal, then what do the remedies look like? Like, what can potential employee expect at the tribunal? And generally speaking, what might the outcome be?
So there's different types of remedies available. Really what the overarching theme the tribunal has is to make this employee whole, or to put them in the position they would have been in had the discrimination not occurred. So for example, if you got fired for something connected to epilepsy, reinstatement could be ordered. So it's an area of law where the tribunal could say, you're going back to work, employer, take this employee back. Another common remedy is lost wages. So if the employee's been out of work for 8 months and they're reinstated, or they're not reinstated, and you get to the hearing and they're successful and they've been looking for other work, they'll typically make the employer pay all the lost wages they would have earned up until that time. Other remedies are non-monetary remedies that can include promotions, letters of reference, things of that nature. And then there's the public interest remedies, and that could be policies, posting the code, training for members of management to address any systemic issues. And then what most people, folk understand when they're thinking about what remedies you can get in the human rights world are general damages. General damages are pain and suffering damages. So what the feelings that you've experienced and the humiliation from having been subjected to discrimination. And those typically range between $10,000 to $25,000, or the average, if someone's been fired, being $15,000. So lost wages, $15,000 in general damages, and some other public interest remedies as well, likely.
Okay. And then I guess your average case wouldn't necessarily just be someone having a seizure and then being fired the next day. It's probably a little more, I guess, for lack of a better term, discreet, right? So what's that like evidentiary? What type of evidence does a employee need to bring to actually make a successful claim? Because I think for individuals with epilepsy, it may, in part at least, be part of the stigma or the inherent biases that are associated with it. And it may not be a specific event in time that is they're able to point to. So how do you even quantify that and bring it to a successful claim within the board and tribunal?
So what we see on TV typically when we watch is proof beyond a reasonable doubt, very high standard that you need to show. That's not the standard at the Human Rights Tribunal. The standard at the Human Rights Tribunal is called a balance of probabilities. And so what the tribunal really is looking at is they're going to hear all of the evidence and they're going to say, on a balance of probabilities, which is more likely than not? Is it more likely that this person was discriminated against, fired, or not received a promotion because of their disability, or not? Is there another reason? And so it's kind of a lesser, more moderate standard of, say, 51% if you're trying to envision it in your mind. And so what you can do is, you want to, if you're going to bring a case, you want to start to take notes. So you want to have some, if you're going into a meeting and comments are being made to you, if you're in the meeting, take notes if you're able to. If you're not, as soon as you get back to your desk or your workspace, write down notes. And those can be contemporaneous notes. So they're things that a lawyer can use when you advance your claim down the road. And they're really important because you're going to, 2 years down the road, forget something, right? And if you have your notes, you're going to be able to go back to refresh your memory. The tribunal is going to give them a lot of weight. So taking notes, documenting things. If you're asking for accommodation, rather than doing it verbally where people can have different recollections of what occurred, send it in, follow up in an email if you have a verbal discussion. So you have a record. Hey, just following up on our discussion, I informed you X, Y, and Z, and I need X, Y, and Z. Look forward to hearing from you, right? Mm-hmm. Then you have a record and they can't deny that that conversation took place. So it's just a matter of documenting and getting ready for the fact that the employer may not remember or they may just simply lie. And so having that evidence is really important when you come to see a lawyer and when you get to the tribunal.
All right. And I think another question that a lot of viewers may be wondering is what does this look like from a cost perspective? Like I guess you and I both know lawyers aren't free. So if this does happen to someone, how do they, what would their expectation be in terms of bringing a claim and being successful at that, right? Do they get to recover costs? What would that look like?
So there are no cost consequences at the Human Rights Tribunal. What that means is that if you win, you can't recover any of your legal fees. But on the flip side, if you lose, you're not paying a big portion of the other side's legal fees. And so, what you want to do in most cases is find a lawyer who might offer contingency fee options or reduced hourly rates or a mix. There's different structures. So lawyers don't always have to be unaffordable for most people. I do a lot of contingency work. I couldn't afford my own hourly rate if I had to pay myself. So, there often is a way to bring your claim forward, especially if it's a legitimate claim. If it's a legitimate claim, it likely means there's going to be recovery at the end of the day. And so what you would say, a contingency fee, for example, would be a lawyer would take some percentage of what they obtain for you, whether it be 20, 25, 30, 33. Those are all common numbers. And what I would also say to you is don't be afraid to negotiate. There's lots of lawyers. And so call a few and ask if they'll reduce their rates, right? Try to get yourself the best representation you can that's affordable. Don't be afraid to ask for that. The worst they'll say is no. Someone will eventually say yes, and so shop around. But human rights lawyers, Mike, just to answer your question, don't typically make as much as other areas of law.
Okay.
The contingency fees are very appreciated by people that know they have a good case, and that's a really good way to go.
Mm-hmm. And then I guess with that as well, how long does the process take? What for a typical claim? You're fired this month, how long can I expect to actually see some resolve, to actually see either my case be heard, or how long would that take? What does that look like?
Yeah, so eventually we're going to be beyond COVID. So I'm going to talk kind of in typical times. Typically what you're looking at is you file your application. The tribunal usually takes a couple weeks. They vet it first, so it doesn't go right to your employer. They look at it, they make sure there's nothing missing. And if they say, okay, this is complete, they will send it to your employer. Then your employer has to file a response. So they have to respond to everything that you've said. And they send it back to the tribunal. And then the tribunal sends that to you, and then you get to file a reply. All of that takes probably 3 or 4 months to complete. And then the next stage, as long as both parties ask for it, is a 3-hour mediation with a vice chair or a member, which is basically a judge of the Human Rights Tribunal. And most cases settle there. 60% statistically will settle at that mediation. Of the 40 that don't, that will be then set for a hearing. And 30 out of that 40 will settle on the first day of hearing or before. So remember, if you file a human rights application, you probably only have you do only have a 10% chance statistically of going to a hearing with that. And the whole process, getting to a hearing, typically takes between 1 to 1.5 years. Their standard is kind of closer to 1 if things are functioning smoothly. But again, you're probably going to settle at 6 or 7 months because there's going to be a mediation, and the odds are you'll settle there. So it's not quite as long as some court proceedings, but it's not quick either.
Okay. Good. Cynthia, I don't know if you had any questions you wanted to jump in with, or any thoughts?
No, we've in cases in the past with the notes, taking the notes was particularly important. Wade, I guess the case I'm referring to, you're familiar with, and the person had years and years of notes, so it was really helpful. Especially that case did settle prior to the actual hearing, because I was subpoenaed, and it didn't happen because those notes came into play and were very helpful. And wouldn't you agree that's a big part of it, the process?
Yeah, to be honest, I think the reason that case settled was also your involvement and other agencies' involvement as well. It signaled that there was support for this employee, which is so important, because it's scary to bring an application against your employer. That's your source of income, right? So that's a big decision for somebody to make. And as lawyers, too often we think, oh, just file the application. We do this 100 times a day. But really, for a person, if you get fired or if they retaliate, that's how you're going to pay your next mortgage bill, for example. And so I think having support and people around you like Cynthia and Epilepsy South Central is really, really important, because it signals to the employer that you have that support. You now have a lawyer. You're ready to move forward. It's not going to be an easy case for them. And you're going to get a favorable settlement, most times, by having that support.
Yeah. It was, and the case went a long time, and the person ended up on going on stress leave, essentially, because the place of employment was unbearable.
Yeah, and that's not uncommon either. When someone's kind of frequently requesting accommodation and the employer is saying no, or they're kind of doing half accommodation, or they're labeling you or stigmatizing you, eventually that results in a poison work environment. You're not going to want to go to work anymore. And what may have been a simple request for accommodation for epilepsy could become anxiety, depression. There's other things that crop up. And so the longer it goes with a resistant employer, the more likely it is it's going to lead to that medical leave, because people get burned out, right? They can't fight forever. And it's tough going into somewhere where you feel you're not wanted or you're not understood.
Okay. So I might just ask one more viewer question, which is somewhat associated to the comments that you were just mentioning. Now, this individual is just pointing out, and I'll speak more in generalities right now, but they've said they have epilepsy in the workplace, and they do have an employer who has been presented with this information. There has been a duty. There has been accommodations made, but it's just, I guess, not working for them. And so they're still facing discrimination in their view. So what would you suggest that at this point, if the concerns have been raised directly with the employer, and accommodation has been made, but clearly it's not working or it's not enough. Would you recommend bringing some form of claim, or would you recommend trying to work directly with the employer some more? I don't know what your thoughts would be.
So I'd start by working directly with the employer first. What's often helpful here in a situation like that where there's some accommodation, but the employee doesn't believe it's sufficient for what they require, is to go to your doctor and explain to your doctor what's not being provided and why it's important. And if there's a medical basis for it, have your doctor write a letter to the employer that you present that says, you know, so-and-so requires this because of this. And try to really lay it out that way, because once you have that medical note, it's a lot harder for an employer to say, no, we're not going to do it, because now it's a clear, understood accommodation need. And so that's usually the first step. Even if someone came to see me, I would say, you know, let's talk to your doctor. Go to your doctor and see if they'll write this letter. Send it to your employer. We'll look at their response. At that point, if it's still, we're not going to support you in terms of what you're asking for, then either I would do a demand letter from me that explains their obligations under the code, hoping that educates them, or I would just file the human rights application and deal with it in the process, depending typically on how close we were to that limitation period.
Okay, great. So unfortunately, we're already out of time. So
Okay.
I don't know, barring any further comments from either one of you, I might just try and wrap it up. I mean, thanks so much, Wade, for taking the time to speak with us. Very insightful, very obviously knowledgeable about this specific area. So it's very great to get your thoughts on all of this. I'm sure the viewers appreciated it.
Well, thank you for
Yeah,
having me.
thank you both. That was very informative, and Mike, you did a great job of facilitating the questions, and Wade, thank you so much for all that insight.
Thank you.
Great. All right, I think that just wraps things up. Thanks, everyone.